Okay, let's talk whole woman's health versus Hellerstedt. 2016, the most recent Supreme Court case on abortion, and boy, were people watching that. Everybody wanted to know what Kennedy was going to do. Kennedy, we'll talk about this later because of one of the cases he authored. Kennedy has sort of been of multiple minds on the abortion issue. It's one of those things that he has struggled with mightily. Of course, he's not on the court anymore, but when he was on the court, he struggled with it mightily. What to do, again, because of this multiple interests in play, he was never sure what to do with this abortion issue. And so in Hellerstedt, as in so many other cases, we were all watching whether the Supreme Court was actually going to overrule Roe versus Wade, which means throw out not only the trimester framework, and I hope you got that was clear from Casey. Trimester framework is gone, unworkable. Along the continuum, there's now one line viability. You have your pre-viability rules, your post-viability rules. Post-viability you can ban as long as you have an exception for the health of the mother. Pre-viability, no undue burden. So, everybody's watching Hellerstedt. What's going to happen? Is the Supreme Court going to overrule Roe in terms of not just getting rid of the trimester framework, but also overruling the central holding of Roe? I keep using that terminology, and that's terminology you have got to know. The central holding of Roe. Lawyers talk about that all the time in those terms. So, in Hellerstedt, not only did the court not overrule the central holding of Roe versus Wade, but it arguably made it a little bit easier to challenge any state law, at least potentially, okay, or theoretically, to challenge a state law that would burden a woman's right to terminate a pregnancy. So, in that case, Kennedy sided with the four liberals on the court, and Roe versus Wade lives to see another day. Now, at a very practical level, Hellerstedt gives you two things. Number one is a couple more examples of laws that were struck down. Right, this Hellerstedt comes out of Texas. There's Texas laws that are challenged, and we're going to see that two provisions of the Texas statutory scheme about abortion, the two that are challenged, are struck down. So you're building a list here, right, like you always do when you're outlining a course. Here are the laws that were upheld. Here are the laws that were struck down. Up to this point, we have a few examples of laws that were struck down. Some I haven't gone over in too much detail, but they're in your reading. Has special accreditation requirements for a hospital that don't apply to hospitals performing similar medical procedures. A hospital abortion committee to decide whether this is an advisable procedure. Those were struck down. We have spousal notice, that was struck down. So now we're going to add two more laws that are struck down, two more types of provisions. The court says there's no reason for it. So that's the first thing you're going to get out of Hellerstedt, is a couple more examples you can use for your analogical reasoning so that you can develop that skill to be a really good lawyer. The second thing you get out of Hellerstedt is it tweaks the test. It gives us a new framework for deciding these cases. So let's talk the second one first. In Hellerstedt, the court says, let's be clear about this. We've not been explicit about this, but now we're being explicit about it. The undue burden standard is a balancing test, where we weigh, on the one hand, the burden on a woman. And you read the case carefully. That's a very practical consideration. That's a very fact-driven consideration. What's the burden on a woman? The court throws a lot of numbers at you. How many women in Texas, right, used to live within driving distance of an abortion clinic versus how many do now? So, driving, time, availability at all, right? I mean, some of these measures just shut down so many abortion clinics that there's maybe one clinic left in the state. They're not talking about the Texas law necessarily, but when you watch the news of what's going on around the country. So you have to, at a very practical level, calculate what is the burden on a woman who wants to terminate a pregnancy, pre-viability. And you weigh that against the benefit. Now, the court, again, was not very explicit about what we mean by benefit. I mean, if you look at Casey, if you kind of back up to Casey, and the 24-hour waiting period that the court upheld in Casey, it looks like there were some sort of public policy considerations. It wasn't necessarily that the 24-hour wait would cause better medical outcomes, better health outcomes. There seem to be some policy implications. So when you're talking about the benefit, it's hard to, well, here we go. Ladies football. When you talk about the benefit, it's kind of hard to know what exactly the court's talking about. What should you put in that pan, right? As you're weighing these two pans against one another. But in Hellerstedt, the court really makes it clear that in that case, it's talking about benefit as to health outcomes, as to positive medical outcomes. So, from Hellerstedt, we know that the undue burden standard announced in Casey is to be applied as a balancing test where you look at the burden on the woman against the benefit to the state, which would be the benefit to the woman, which would be a positive medical outcome in most cases. So, why do I say this test might make it a little easier for the challenger? Well, under Casey, there's no balancing. Right? Casey didn't announce a balancing test. So under Casey, we're just trying to figure out, is it too big? Too big as compared to what? Who knows, right? I mean, again, the rule announced in Casey was not very helpful. And it looks like what the court was saying in Casey is, we're okay with abortion restrictions as long as they're not really onerous. Now in Hellerstedt, the court comes along and says, well, the burden is undue if the burden outweighs the benefit. Now, it's easier to argue if there's no real benefit to any law, that even if it's not a big burden, an onerous burden, it's still unconstitutional because the burden outweighs the benefit. So, again, a good lawyer would use this, manipulate this, right, to try to make it easier on the challenger side to win a case. We'll see where the court goes with this. I can't say this, enough. Kennedy is gone, replaced by Justice Kavanaugh. Justice Kavanaugh has written when he was on the D.C. Circuit about abortion, the abortion issue, and he definitely seems to be coming from a different place than Justice Kennedy was. So you need to keep an eye on these abortion cases and where the court goes with it. My money is on they're going to tweak the balancing test to put their thumb on the scale on the side of the state. But that's not something you need to worry about for my exam or the bar exam, unless it happens between now and your bar. All right. Let's talk about the two provisions of the Texas law that were at issue and how the court applies the balancing test. There were two parts of the Texas law. Number one, it required admitting privileges. Right, a doctor performing an abortion at a clinic has to have admitting privileges at a hospital within 30 miles of the clinic. What that's going to do, obviously, is cause tremendous logistical problems. Obviously, first of all, you're going to have clinics that are not within 30 miles of a hospital. And when you read through that case, you see that it would be very difficult for a doctor at a clinic to obtain admitting privileges at a hospital, because admitting privileges typically go to physicians who actually admit patients on a regular basis. And this gives the court an opportunity to say, I hope you caught this, right? This one witness said there were 17,000 abortions at this one facility, and not a single one of them resulted in a patient going to the emergency room, never mind being admitted. So a doctor who never admits patients to a hospital is not likely to get admitting privileges. What the court says here ultimately is that this admitting privileges requirement is a solution in search of a problem. The purported reason to have admitting privileges requirement is for the safety of the woman. That, right, if there's an emergency, the woman can quickly be admitted to the hospital. First of all, as a practical matter, the woman can be admitted to the hospital anyway, because if you go to the emergency room, then the doctor in the emergency room can admit you to the hospital. Bottom line, abortion, people are on different sides, obviously, of this issue. When it comes to the medical reality, abortions are quite safe. The court says we discern no reason why you should be requiring admitting privileges, right, to a hospital within 30 miles when the record reflects so few hospitalizations to begin with. So what's the benefit? The court says there is no benefit. The burden is it's shutting down clinics because a lot of doctors simply cannot meet the requirements of the law. They can't get admitting privileges, or they're not close enough. Big burden. It's shutting down clinics. It is making drive times longer, all that stuff, and the benefit is essentially zero. And if you got a big burden against zero benefit, then obviously the burden outweighs the benefit, and the burden is undue. So there you go. That's how the court applies it in that instance. The second part of the Texas law that's at issue is a surgical facility requirement that abortion clinics have on-site certain level of surgical facility. Now that too, you can imagine the expense involved in creating a surgical facility on site if you don't already have one. So the burden there was the same as in the admitting privileges case, that it was shutting down clinics. Clinics were just saying, if we have to have an emergency room grade surgical facility on site, we don't have the money for it, we can't do it, and we're just closing the clinic. So you have the same burden, right? Closing down, increased drive times, all that stuff. And what's the benefit? Well, the court now gets again into the medical stuff here. Many early term abortions anymore involve taking a pill and going home. So those procedures are not happening, right? Those medical procedures are not unfolding at the clinic to begin with. So having a surgical facility at the clinic is not going to do a woman any good when she's at home. Furthermore, again, the court says, and look at this constant reference to, are you doing the same thing with other medical procedures? The court lists a bunch of other medical procedures that are actually more dangerous than abortions, where the state does not require an on-site surgical facility. Again, you have the example of a colonoscopy, for example, which is far more dangerous than an abortion procedure, and yet there are no requirements for this kind of facility on site. So once again, the court says in many cases there's absolutely no benefit to this, and the burden is onerous. So once again, the court says if the burden is onerous, very heavy, and there essentially is no benefit in many cases to a requirement like this, then obviously the burden outweighs the benefit and is undue. So that's how you apply the undue burden test. You look at what burden does it play. You mine the fact pattern. What facts do I have here about the burden that is placed on the woman who wants to have an abortion, right? And look in the fact pattern, what is the alleged benefit? The court here says there is no benefit, there's a big burden, therefore undue burden. If it had said the opposite, if there was a medical benefit, if it was real, measurable, concrete, then the outcome might have been different. What's the court really saying here? And I always struggle with how to discuss this issue. But if we can get real about it, there are very strong advocates on either side of this issue. And what the court is really saying here is, the state of Texas, you're saying that you were trying to achieve positive, right, beneficial health outcomes. What the court is really saying here is, we don't believe you. We think you're imposing these restrictions to shut down abortion clinics. If that's the purpose of the law, obviously, and all through these cases you see, if the court suspects that that's what's going on, that a state is just trying to close down abortion clinics, is just trying to make it harder to get abortions, for political, philosophical, religious reasons, whatever the case may be, that is unconstitutional as long as the central holding of Roe still stands. So that's a wrap on Hellerstedt. And now you have your, again, multiple examples from Casey, Hellerstedt, and other cases of laws that were upheld, laws that were struck down. So I'll be asking you some questions about that in a Campus Studio video, but that's a wrap. Those are the two really big cases, Casey and Hellerstedt, and we'll fill in some of the, we'll tie up some of the loose ends in the live session, but this is a good start for that conversation. So stay well and stay tuned.